So, the Alzheimer's Society of BC would like to respectfully acknowledge that it operates on the traditional territories of Indigenous peoples across the province. Our provincial office is located on the territories of the Musqueam, Squamish, and Tsleil-Waututh nations, with regional resource centers located on traditional territories in all regions of BC. I'm hosting today's presentation from Port Moody, which is located on the territories of other Coast Salish peoples, the Kikite, Kudsi, and Quiquitlam people. We make this acknowledgement to draw attention to the fact that the Alzheimer's Society of BC's vision for a dementia friendly province will only be possible through ensuring that everyone living on these territories will have access to support that is culturally safe, barrier free, and free from racism. And I'm going to stop sharing for a moment. And I have the very great privilege of introducing today's presenter. Some of you might have joined last week when our session ranged over quite a wide range of topics related to dementia and personal planning. Today, we're really pleased to have Martina Zanetti, who's a director of programs for Nidus Personal Planning Resource Center. Martina is also a lawyer with an extensive background in estates law, and she shares the responsibility of providing presentations and training to the public on personal planning and representation agreements. And so it's truly a privilege and a joy to have you with us today, Martina. And on that note, I am going to turn it over to you.
Thank you so much, Lori, for that really warm welcome. And hello to everybody on the internet. I was really happy to see the wide range of locations that people join us from. And that's a real privilege for Nidus to be able to have that reach, to partner with the Alzheimer's Society, and and I guess it's one of the benefits of the internet, right? So today I will be talking about just the essentials of personal planning. And here at Nidus, we have a special expertise in representation agreements. And maybe, but of course, we're going to also talk about personal planning more generally and other areas for finances and other matters. You may have your own representation agreement and you just want to hear about updates or want to share more information with friends. Or alternatively, maybe you have not heard of them before and this is your first foray into this. But I think certainly learning about them today will be one of our learning objectives. About me, like Lori said, I was in private practice in downtown Vancouver and West Vancouver over my career for 10 years. And then actually just this year, I decided to switch paths out of the private practice of law and to do more public facing legal outreach like this. I found it really fulfilling so far, but I want to sort of acknowledge that I'm not providing legal advice, though I am a lawyer. It's not specific advice to your situation, but what Nidus does is provide legal information so you can undertake self-help and feel confident if you want to hire a legal professional to help you too. Okay, I'm going to go to my next slide. So Nidus, who I work for, is a charitable organization. It is not an acronym. It's actually a Latin term for nest, a symbol of support and safety. And we want to be that for people who are supporting others or who are looking into personal planning. But we also feel that it's a symbol of what a care network and a representation network looks like for adults who are doing personal planning. So we're a nonprofit, and we were actually set up back in 1995 when the British Columbian government was undertaking a update to its adult guardianship legislation. So adult guardianship is about when a court imposes authority for somebody to make decisions for somebody else. But we felt, the grassroots community, led a lot by parents of children with disabilities and also seniors, wanted an alternative to adult guardianship. And so we were involved in the creation of the Representation Agreement Act and the creation of representation agreements as a legal document. And since then, we have been continuing to provide these three areas of branches of our programs, which is legal information, doing webinars like this, tons of info on our website if you want to learn more, and then providing free forms of representation agreements if you want to make one for yourself or support others to make them. And we also run the Nidus registry, which is a secure storage for information and copies of your planning documents. And I'll talk about that at the end, especially if we have more time. So these are my learning outcomes from today. It's going to be a lot of information. And I had a mentor in private practice that said, everybody needs to hear something 3 times before it really sinks in. So I was glad to hear that Lori said that there had been a workshop earlier this month that maybe, or week even, that started to lay some groundwork. And but I still realize that you may need more info afterwards. So like Lori said, we're gonna have a Q&A at the end. I'm not following the chat just because I find it a bit distracting to talk while also doing that, but we will have time at the end for questions. And you can also email us if you want a copy of this presentation, the slides, or if you have further questions, and I will post our address on the very last slide. It'll be up for the entire Q&A session. Okay, so what really is personal planning? So we often, I'm gonna get out my handy dandy laser pointer. So we often focus on this end of this planning tree, which is estate planning after after your death. But what about while you're still alive, but might need assistance, support, or actually someone to just make those decisions for you because you are maybe unconscious or very unwell? So that's what personal planning covers for while you're still alive. The law sort of breaks our life into these 4 categories, for better or for worse, and it provides documents to cover each of those areas of authority, as we call them in the personal planning realm. Probably as connected with the Alzheimer's Society, you've heard about advanced care planning. That's kind of a subset of health related and medical planning, but personal planning is more. So it's all 4 of these areas. So why exactly do we need to do personal planning? The reason is that when someone in British Columbia turns 19 or becomes an adult, everybody is assumed capable and no one automatically has authority to act on that 19-year-old's, that adult's behalf. So there's a lot of misconceptions that parental or guardianship rights might continue for parents of children with disabilities, for example. That's not the case. Those guardianship rights do end. And so, and obviously we can also be, each of us, impacted by sudden loss of capacity or, more gradual because of medical conditions, dementia, etc. So it's best to plan for needing help because in most likelihood, all of us will need that help at some point in our lives. So an adult can either be proactive in doing the planning and making a legal document, or the authority can be opposed, and a default scheme under the law is imposed on the adult for their decision making. And I'll discuss that a little bit later. But really, we're going to be talking about being proactive and appointing trusted persons to have legal authority for you and having a say in who that is. So what legal documents can you make if you want to be proactive? Though that depends on a couple of different things. So in each and every legal document will have a age requirement, and that you have to be an adult in order to make it. But each also will have a mental capability requirement or threshold. And this will be different for every single type of a little bit different for every document, of course, because nothing can be simple, but also but at the same time, a lot of documents are based on the traditional definition of capability or capacity. So let's now look into, So let's first look into those different types of levels of capacity. So the top there is the traditional definition of capacity to make planning documents, which most people, most everyday people that are not impacted by developmental disabilities or mental conditions that affect their ability to understand. Most people out there in the world will meet the traditional definition of capacity. That's the ability to understand the nature and effect of the legal document at the time that you're making it. And so that kind of means what does the document say generally? It's understanding what the document says, the consequences of making it, what it can be used for, maybe your obligations, what you have to do under the document and what somebody else has to do under the document. And this is the traditional definition for wills, making contracts. But I talked about that law reform, and this is where that law reform really happened. So in Section 7 of the Representation Agreement Act, we have a different definition of capacity, and everybody is assumed capable of making a Section 7 representation agreement under that section of the Act, even if they don't have the capacity to understand the nature and effect. And so even if they don't meet that traditional level of capacity up top, they can still have, they could still meet this threshold, even if their ability to understand is in question. So this is not a cognitive-based test, and a medical note is not required to determine which path you're under. But like I said, most people meeting the traditional will meet the traditional definition of capacity, and then some will not, but creating a representation agreement under Section 7 is still possible for them. And the reason why this change was so important was because, again, our grassroots community was a lot of people with children who have disabilities from birth. They knew that their children had preferences, abilities to communicate those preferences and indicate people who they trusted, who they felt comfortable around. But after the child turned 19, they had no recourse to have legal rights to support their child in making those decisions, expressing their preferences, without going through a court process of adult guardianship, where the now adult child really lost a lot of their rights. They had to be certified incapable of making those decisions, and their say just wasn't included in the decisions that were being made about them. So like I said, these parents knew their children had something to contribute, and they sought to make a document that could allow them to do so without this expensive, costly, and rather undignified process of having to apply for a certificate of incapacity for their child. So we did get that document, which is the good news. And this picture here sort of lays the two different definitions of capacity on top of each other, the different paths, as we call them at Nidus. And then we have those 4 different areas of personal planning authorities that you can appoint someone for. And below, we have the associated document that you can make. So first, for the great majority of people, there's that traditional definition of capacity. For health and personal care matters, you can make a representation agreement under Section 9. That we call that an RA9. And that's a representation agreement that meets the traditional definition of capacity. It's the only document you can make to appoint someone for health and personal care, a representation agreement. And it covers those areas. And it's a companion document to usually an enduring power of attorney, which covers the legal and financial sides of your life, and is often prepared at the same time when you're doing your estate planning. These people will often create a will, because the traditional definition of capacity for most people will they'll be able to create all 3 of these documents. And a lot of people will go to a lawyer or notary to prepare all 3 of these documents at the same time. But you don't need a lawyer or notary to create a representation agreement under Section 9. You can do that yourself. And you don't have to sign it in front of anyone. And that's why Nidus provides forms. I'll talk about that later. If perhaps somebody has had developmental disabilities since birth, or if during a time when they were cognitively capable, they did not make these documents, they still have an option, which is the representation agreement, Section 7. So I stress again, especially because this is an Alzheimer's Society presentation, a lot of people, when they first get their diagnosis, are encouraged to make these 3 documents. But if that doesn't happen, or too much time goes by and they're no longer capable of making these documents, they can still make a Section 7 representation agreement. And as you can see, that document goes right across the entire 4 areas. So it does include some limited ability to do routine financial affairs and to cover legal affairs. So it's a really good option in the alternative to, like I said, something like adult guardianship. Okay, I want to just introduce, take a little bit of time on this decision-making continuum. And introduce this concept because, personal planning, when we think about it, we still sort of fall into thinking about the 2 ends of this spectrum of decision making, where, you absolutely don't want, you're absolutely independent, able to make decisions for yourself. Often you really want to guard that. Sometimes there's a fear to lose that independent side. But at the same time, we think about situations where somebody has to just completely make a decision for me because I am not capable, and obviously not capable. I perhaps coma, unconscious due to medical emergency, etc. But in reality, I would say that even for everybody, more decisions happen in this in-between area. So that might be because it's not clear yet, or the person is in between, true incapability or not being able to participate in those decisions versus absolutely able. So, that gray area sometimes of dementia that can fall into this part. And so can when we just don't have enough information, right? If I'm not an accountant, I might want to talk about some of my tax matters or my questions about tax with my sister-in-law, who is one. So whether it's because you just need a bit more help understanding concepts, or it's because capacity has started to decline, really we're more in this area. And this, we'll see later on, is actually, there's an ethical decision-making process that goes with representation agreements. And it actually these documents give people access to this area, this in between, and allows people to continue to participate in decisions when they're in this in between spot. So some people worry that in making a plan for this side of the spectrum, substitute decision making, they're losing control of this side of the spectrum. But in reality, I would say they're lengthening their time where they can make, where they can provide their impact, their input into those decisions. Okay, so again, I said there kind of are two different types of representation agreements. A representation agreement is, again, the only document that covers healthcare. But there are two different kinds, that RA9 under the traditional path of capability, and then the RA7 when people do not meet the traditional path. There are, like I said, the Section 9 representation agreement is the broadest powers that you can give for healthcare and personal care. So you can refuse life-saving treatment or care if that's what you decide. Your representative rather can be authorized to make consent to specialized medical procedures, including experimental procedures, if you really want to go down that route. And under a rep agreement, you can also make temporary care for the education and custody of your minor children. If you are a young person with young children, you might want this if, for example, you are undergoing surgery, especially for single parents who maybe have sole custody, so don't have somebody else to rely on. The Section 7 representation agreement, available to those who have who don't meet the traditional capacity standard, has the healthcare and personal care aspects of the Section 9 representation agreement, but you can't do these things. So these are not part of the Section 7. But what is part of Section 7 is financial affairs and legal affairs as an alternative to a power of attorney. But again, these powers are somewhat limited. For example, financial affairs are only routine financial affairs. That's established under the law, but that's like, you know, bank accounts, paying bills, depositing benefits, applying for benefits, doing taxes. It covers a lot of everyday things, but it does not cover real estate. That was a limitation that the government felt was necessary. And there are some, I guess, admissions to care facilities that also can't happen under here. Even though living arrangements is covered, there's certain care facilities that you can't consent to. So although RA7s are a gift because they expand those people who can make a document, they are limited, and that's a bit of a compromise because of the diminished capacity that the diminished threshold of capacity that's needed to make that document. So I think it's always great to walk through some real, some examples of when these documents are used and when people make them. And so here are a couple. We're going to do some for the representation agreement under Section 9, the RA9, and a couple for the RA7. So Beth was recently diagnosed with early stage Alzheimer's disease, but clearly she still did have capacity to make an RA9. She still met that traditional capacity threshold. So she named her husband as her first named representative, and she named her daughter Sarah as her alternate representative. So now the people she trusts and who know her best will be able to ensure she's treated with dignity and respect, even as her capacity declines or is affected by her dementia. And equally important, her husband, Hank, who has no diagnosis whatsoever, also made an RA9. He wants his affairs in order too, but he doesn't want to put that responsibility on his wife, Beth, who's dealing with her own medical issues. So he's appointing Sarah, his daughter, as his representative, and his son as his alternate representative. So that's an example in that context. But just to kind of put it home that people of any age should have a rep agreement, you know, we are reminded that we don't know what's ahead of us. So something like a brain tumor can strike somebody quite young. So here, Michael, that's exactly what happened to him. But soon after his diagnosis, while his capacity was not impacted, he made an RA9 and named his friend Gustav as his representative. Michael did take part in experimental therapies at the beginning of his diagnosis early on, but he decided he doesn't want further treatments, however promising. And so he's making sure that Gustav can refuse these treatments by making that RA9. He also would have conversations with Gustav about those wishes and values. So Gustav knows this. But just because Gustav is being asked to say no to some types of medical interventions, he is still authorized to say yes to others. So he can consent to pain medication and comfort care as Michael continues to live through his condition. Now for an example of an RA7 representation agreement under Section 7 for those whose abilities to understand is in question. So Joyce, when she was first diagnosed with Alzheimer's disease, she did meet the capability requirements to make a will, and she did that. But as Joyce's dementia had progressed, she now needs help with healthcare and personal care decisions and making arrangements to pay her bills, deposit money from her pension, etc. But since Joyce has not passed away, her will has no effect. So she needed additional planning documents. But now that her capacity is diminished, she instead makes an RA7 all. That's the Nidus short form for a representation agreement under Section 7 that includes authority for all of her different areas of life. It includes routine management of her financial affairs. She names her friend Barb as her representative, and this gives Barb authority to pay Joyce's bills, etc., like needed. And it also covers health and personal care, so Barb can help ensure Joyce gets access to good care. Barb can be present if desired during medical appointments to hear the same info as Joyce and help her speak up. And she can pick up medications and communicate with healthcare providers if needed. And I really like to tell this story because this is a real life example of somebody who Nidus helped out and let us share their story. So Mary, who's the gal on the right here with the birthday tiara, looking fabulous in pink. I guess they're both wearing pink. Mary's the one with the pink tiara. She made an enduring power of attorney while she was capable, and she named one of her daughters as her attorney. But Mary later developed dementia, and her daughter that was named in that enduring power of attorney, she was no longer able to act. I think she actually passed away before Mary did. So because of her dementia, she couldn't revoke her old power of attorney, Mary, and she couldn't even make a new one. I think she went to her lawyer, and they said, or notary, and she said she was not capable of the traditional level. And she said, no, I can't make a new power of attorney for you. So the options were limited here. She could apply for committeeship, which is that adult guardianship process that I told you about, or that I will be talking about later. But this would give her other daughter that she wanted to appoint, would give her daughter legal authority about her finances and other matters, but Mary would lose rights. She would be declared mentally incompetent. That's the language used under the legislation. And she would not actually have there would be no obligation for her to be consulted and involved in the decision making. I'm sure her daughters would have done that anyway, but it's just not part of the scheme. So not only that, but that commutation process is very expensive and time consuming. So Nidus instead provided Mary and her family with information about the RE7 and the powers that it includes and the areas of authority, those 4 areas of authority that she could appoint someone to take care of. And she did just that. She made an RA7. She appointed one of her daughters as one of her now available daughters as the first representative, another available daughter as the alternate representative, and she appointed her granddaughter as the monitor. We'll talk about that, but the monitor helps to safeguard the adult and make sure the representatives are doing their job. And this made a network for Mary. So not only was it her and her one daughter previously, but now it's her 2 daughters are being involved, and she likes to have her granddaughter involved as well, because they're all involved in this agreement, right? And now she feels much more connected. Previously, she felt cut off, but now she feels not forgotten. She is really happy to have not had to go through the process. Her and her family are happy to have not had to go through that process of commutation. And she recognizes that now she has a team, so she feels safe and in control. And so everybody's really happy with the outcome, but also a real life example of how this can work. So I talked about this a bit, just high level, but what are the different roles in a representation agreement, and who can be appointed? So obviously there's a representative. That's the person who would support the decision making of the adult who made the representation agreement, or will step in as a substitute if needed, if they're incapacitated. The representative is subject to duties that I'm going to talk about later, a standard. There are some restrictions on who can be a representative. There's not many, but there is one important one. They need to be an adult themselves, okay? And it can be really anyone, a family member, a friend, a trusted person in your any trusted person in your life. But if a person is a paid caregiver, they're providing healthcare or personal services to you, the adult, you cannot name them if they are being paid to care for you. The only exception is if that paid caregiver is your child, parent, or spouse. So generally, no paid caregivers can be your representative unless they are your spouse, parent, or child. Okay. Alternative representative essentially steps up into the role of the representative if they can no longer act. And the monitor is required. It's different from the representative because they're not making decisions instead, or supporting decision making. Instead, like I said before, their lead duty is to ensure that the representative is doing their job properly and in line with their duties as a representative. So they're a check and a safeguard for the adult. And you know, if there's conflict, they can try to mediate. If there's questions about processes, they can try and work on that too. Ultimately, the monitor has a duty in the law to report to the public guardian and trustee, a government body, if the representative is failing in their duties and they can't resolve it. So the monitor is really there looking out for the person. And if they feel like that person's representative is not acting appropriately, they have a duty to tell the a government body who can investigate and do more. Okay. They also have powers like asking the representative for information, getting copies of their records if they need to. But the main duty is to just make sure that the representative is doing their job properly and that the arrangement is working for everybody, especially the adult who made the document. So making a representation agreement, there are formalities to signing the document. I'm not going to cover this too much because, like I said before, Nidus has very careful resources, step-by-step guides about how to make a representation agreement and forms to do so, and a very careful guide about how this representation document has to be signed. So it does have to be signed by everybody, all of those people that I talked about in my last slide, but not at the same time. The adult has to sign in front of witnesses, and that all has to happen in the presence of each other and at the same time. But then everybody else, the representative, the alternate, the monitor, can sign separately on a different day or different days. And they don't need witnesses, and so that makes it very convenient. But they should sign soon after so that everything is in place if the document is needed. And there are some restrictions on who can act as witness, but again, it's all in our step-by-step guides on the website. As I mentioned, representatives are required by the law to meet certain standards of behavior and action as representatives. And that includes following this ethical decision-making process that's baked into the legislation, the law. And I'm going to point out right now to you that best interests are not the first step of that decision-making process. It's actually lower down, but we'll talk about it here in a minute. So firstly, you have duties as a representative to act honestly and in good faith, be careful, and exercise the skill of a reasonably prudent person. And what I say about that is, you have to be careful. You can make mistakes with your own money and your own affairs. You're allowed to do that if you want, but you ought to treat the affairs of somebody else that you are stewarding with extra care and prudence or carefulness. And then you also have to act within the authorities that's given in the representation agreement that you're appointed under. So you want to read the document to make sure there's no conditions or little parts in there that you've missed or that you're not able to do. Then when considering a decision as a representative, the representative first has an obligation to consult to a reasonable extent with the adult who made the document to determine what their wishes are right now. And if those right now wishes are reasonable, the representative should comply with them. Maybe you can't get the wishes right now because the person is unconscious, or maybe the wishes are clearly unreasonable and are very harming to the person, or seem to be not in line with reality. Maybe they have delusions, something like that, which is a real occurrence sometimes. If you can't get their wishes from right now, or if those wishes are unreasonable, you have to comply with wishes that the adults may have expressed while they were capable. And so in that situation, you might think about discussions that you've had with the person. And we encourage those discussions to happen about things like end-of-life care, palliative care wishes, etc. I'm sure lots of information from the Alzheimer's Society about that. Or it might be a letter of wishes that was left for the representative in a circumstance like this. And so you want to comply as best as you can with those previously expressed wishes. Maybe there was no wishes that were applicable, or maybe there were just no wishes at all. Then you try your best to comply with the known beliefs and values of this person based on you as representative knowing them and knowing other parts of their lives, other discussions that they may have had. And if those beliefs and values are also not known, only then do you go to best interests at the bottom here. And so here, best interests are like what would generally people recommend to do, what you think is the right thing to do, what leads to the best outcome for the person based on the options available. But still, in the meantime, we have to respect and we want to ensure that that adult has a say in what's happening to them. And so they need to be consulted, and their beliefs and values and wishes, if they're able to give them, we want that to be centered before we hop to what the representative or the law, etc., thinks is in the best interests of the person. Representatives are also required to keep records about what they're doing, decisions that they make, especially around managing funds. If you are doing that routine management of financial affairs for somebody, you must keep those records, especially if it's an RA7. It's an obligation. Moving now to the other document for those who meet the traditional capacity. So we have the RA9 for your health and personal care. Now, power of attorney for financial and legal affairs, those other areas. So again, it's used while you're alive. It's not effective after your death. That's your will. You can appoint a person or persons to be your attorney. That doesn't mean they're a lawyer. It just means that you've appointed them in this role called attorney to make or support you in legal and financial decisions. There's lots of different types of powers of attorney. There are types that end if the person who makes the document becomes mentally incapable. There are some that are specific and only cover specific assets, like a bank power of attorney, although those are going out of style, I would say. But the ones that I'm talking about for personal planning is called an enduring power of attorney in British Columbia. And the enduring power of attorney includes those broad powers, but it does not end if the person who made it becomes incapable because of illness, disease, accident, dementia, etc. Instead, it continues after that capacity, so the person can continue to support and substitute those decisions. So why make the enduring power of attorney? Very important if you own real estate. Who can you appoint? Oh, sorry, it's very important if you have real estate, especially and still if you have joint ownership. A lot of people think that if you have your house is joint and you own it together with your spouse, for example, that don't worry, we're both on it, so we'll both be able to take care of it if one of us is incapacitated. This is not true. If you need to sell or refinance the house, you do need the person on title, every person on title, to be able to sign. And if one person is incapable, you need a document with legal authority for somebody else to sign on their behalf. You can appoint a spouse, children, friends, other relatives. Some people appoint professional trust companies, often affiliated with banks. They might appoint other professional advisors, although that will come with a cost. They are professionals, so they charge fees. And so take a look at that when you're considering a professional appointment, maybe shop around, that sort of thing. So I'm now moving to a situation where you have not been proactive in your planning, and we have this imposed authority. So a court, and what that's really called is when a private committee, that's the legal pronunciation, when a private committee is appointed by a court to make personal, financial, or legal decisions for an incapable adult. And as I mentioned before, in that process, the person is declared incapable. They don't have that same input or same obligation to be consulted and have their known beliefs or current wishes involved in the decisions. And so we want this to be a last resort. And that's why we encourage people to plan or make an RA7 if they're in that gray area of capacity, because a lot can be done with that RA7, and we can limit the situations where comiteeship might be needed. They're also so expensive. Like, this says that the legal cost begins at $7,500, but I think that's low from when I was practicing. Like, these can go very high in the tens of thousands, and certainly if there's conflict in the family that is more likely to create an issue, why not instead plan, and you have the say in who that appointed person is. Some people, I'm just looking at my time. I want to ensure that there's at least 10 minutes at the end. And so I'm going to pop ahead a little bit. I wanted to ask Lori, if we're a little bit late, like.
Absolutely.
Okay.
We actually have through until
Oh, that's
3:30.
right. I always
So
thought of
yeah,
an
so
hour.
you don't have to rush.
So
If you
relaxed
yeah,
now.
so we've got
Good.
lots of questions, and so
Good.
we will have time to get
Okay,
to
good.
those.
I forgot. Okay,
No
that's great.
worries.
No skipping ahead. So we talked about what happens if we don't proactively plan. Yes, we want to avoid comiteeship if by proactively planning. Some people, I'm going to turn now to the more medical side of the consenting. A lot of people have worries about consent to medical care and by a substitute. And some people, even with this idea of a representative who can be your alternate and talk to your doctors, etc. Some people want even more, want more. They want to talk directly to the doctor almost about their wishes. So there is this document called an advance directive. And it's a written document where you may give or refuse consent to specific healthcare matters. But the instructions that are in the advance directive must clearly articulate and apply to the specific healthcare situation that arises at the time consent is sought. So you're trying to remember, you're making this advance directive now. And what you're trying to do is think ahead as to the types of healthcare you might want. But maybe in 5 years' time, when something happens, maybe the options before you are different. Maybe the type of care that you wanted to refuse actually has been improved or has become more recommended. And so you don't really have that flexibility. Or maybe the instructions are not that careful, or it's very hard to predict what exactly the question will be when the time of consent is needed. And so there's actually some social science evidence that says these are really hard to apply and sometimes don't get applied in the circumstances because it's difficult to interpret them in the right way or apply them to the facts that are there. So what Nidus recommends instead is to have a representation agreement instead or in addition to your advance directive. If you have both, the representation agreement supersedes the advance directive. So the representative still gets to make the decision. The representative still gets to make the decision, but they're obligated, remember, to take into consideration your values and your beliefs. And so if you made this type of document, they could look to the advance directive to inform they would be obligated to look to the advance directive to inform their decision on this consent. And maybe it does apply very specifically, and so they can carry that out. But what having a representative provides is that safety net, that if the advance directive doesn't properly apply or can't be applied with any real meaning, then at least the representative can be there, can be more flexible to talk about what the diagnosis is, what the outcome, and what the recommended treatments might be. So although the representation agreement supersedes the advance directive, if you're very adamant, you can write in your representation agreement that you want the advance directive to take precedence. But I would still be more comfortable if having both is more recommended, because it catches where the advance directive might not apply. Okay, so with that, a kind of introduction or talk about advanced care directives, let's talk a bit about what healthcare consent looks like for in every day and in the law. So when you're before a healthcare professional, and that has a pretty broad definition, anything done for therapeutic, preventative, palliative, diagnostic, cosmetic, or other purpose related to health. If you're before a healthcare provider, they have to obtain from you informed consent to the healthcare they're about to provide you. And so they have to do that in this way. They explain all these things to you, and then ensure that you're capable to make the decision, and then get that consent from you. I don't know if this has necessarily happened to me in every single case of medical decision making, but that is what ought to be done. So in getting that informed consent, the question is from who when somebody is in front of them, and maybe especially if that somebody is incapable or appears incapable to the practitioner. So this is the healthcare decision hierarchy of who we go to when we need consent to healthcare. So if at the top there, I've included the committee first, that imposed authority. I put that committee first because in that situation, we've already got an incapacity finding by a court. So if that incapacity finding has already been made, the doctor goes directly to the person who's been appointed by the court. They don't even have to consult with the individual themselves. So that falls under the determination of that falls in the situation of no determination of capability being made by the healthcare provider because the court's already done it. Also, if the court hasn't done that and there's been no determination of capability or incapability by the healthcare provider, then the healthcare provider deals directly with the patient. And they can also include the representative if the patient that's capable wants. But like I said, they've got legal status to be there now. And so the medical practitioner can feel confident that they can share information with the representative if the patient asks. Okay, so you get consent from the patient, but if requested, you can involve the representative. If the healthcare provider finds that you are actually incapable of that informed consent, they see you and they make that medical assessment based on their own laws that govern their profession. If you're incapable, then they go to the representative appointed in the representation agreement. And if that was not already in effect, maybe they don't have one, they could go to the advance directive. Again, if they have a representation agreement, it would supersede the advance directive, but the representative would probably still take it into account. If the advance directive doesn't apply to the specific situation at hand, then we go to something called a temporary substitute decision maker, or TSDM. And that is a decision maker who is temporary. So they are only deciding the consent question at hand. And it's predetermined by statute. And it's a hierarchy list. And it's dependent on who's available at the time, or if you don't have that person in your life, they go down the list. So first it will be your spouse. If your spouse doesn't pick up the phone or isn't there to make the decision and substitute, you go to an adult child. Any adult child will do, no priority amongst them by age or anything like that. They're just going to find the adult child who's first available. If no adult child is available, then to the parent of the person. But if this is an adult, probably maybe that person's not around anymore. They'll go to the sibling, grandparent, etc. There are some limitations on who can be a temporary substitute decision maker. So going down this list, they have to be an adult, of course, can't be an actual child. They have to have been at least in contact with the adult in the past 12 months and have no dispute. So I'm not really sure how a practitioner is going to figure out if you have a dispute with one of your kids, for example. But case law has said you don't have to be a private investigator. You don't have to like go and try and really dig deep, because these issues are often emergencies or urgent. But still there is some amount of, there are some, I guess, criteria. And you'll also notice that all of these people are relatives. So maybe you are not really, maybe you're estranged from your family. Maybe you are not estranged from your family, but you have concerns about who in your family is more likely to follow your wishes and have values that align with yours about these kinds of decisions. And so you're more confident for them to make that decision than somebody else in this list, maybe somebody who is ahead. So if you make a representation agreement, you get to decide who out of this list gets to make the decision for you. You can also see that, if a spouse is not available, I'm sorry, I should say it this way. You can also see that because this is a temporary position, it's just about the decision at the time. So it could be a different person making medical decisions at each time consent is required. And that's not really good for continuity of care, right? We want the people that are helping us or making decisions for us to have that consistency of information, of understanding of our beliefs, etc. It's temporary, and that also means it's limited. So it doesn't have any authority for personal care decisions. And it doesn't apply in emergency situations. So a temporary substitute decision maker, they're going to give you the care in emergency anyway. If a temporary substitute decision maker can't be reached, they're going to provide care anyways. And there's also no general authority to refuse life-supporting health care. So if, end-of-life care decisions and not having heroic measures are very, like tube feeding, respirators is very important to you, then don't rely on temporary decision makers. Don't rely on just the relationship with your spouse, or, the relationship of child and parent or spouse and spouse for this decision making. Make them your representative instead. Make your spouse the representative. Make your child the representative if that's what you really want. Okay, because this is going to make a lot more of a difference in continuity of care and what they're able to do in healthcare and personal care matters. This person is very limited. And so I hope that what I have imparted on you is the benefits of planning either before capability is in question or even after capability is in question, at least with a Section 7 representation agreement that can cover all 4 of those authorities of personal care, healthcare, financial affairs, and legal affairs. One of the things I realized I didn't mention is what personal care really involves. And so while medical care might seem obvious, personal care, I can't believe I got to this point of the presentation, personal care involves where the person will live, what activities they participate in, food decision, everyday living decisions like dress, that might include gender identity and expression, helping with those aspects of everyday life. And certainly making arrangements for other daily things like bathing, hygiene, that stuff, which is not technically therapeutic or medical for a healthcare purpose, but it's maintenance. It's about living healthfully and with dignity. Okay, and so again, those benefits of planning for those 4 areas of financial, legal, medical, and personal care is that you're legally and directly empowering someone to assist or support you, and also to make those decisions if you simply cannot. You're able to, in planning, you're able to identify the specific decisions the representative can or can't make and what areas you would like to appoint your representative in. I should mention that you can split out these agreements. So you can have an RA7 for health and personal care that might appoint one child, for example, who's really adept at those things. And you could have another RA7 that just covers legal and financial affairs, and maybe another child is really adept at that. That's a possibility. But a lot of people will just have one RA7 covering all 4 if they are at that capability in question level. So you're identifying the specific decisions, the areas of authority the representative can have authority on or cannot. You are providing comfort because you know that you've appointed somebody who must follow your known wishes and beliefs at the time or pre-existing too. And I again would I often encourage people to have discussions about this with their representatives because that's the best way that they will know your wishes. You're able to override the statutory scheme for healthcare. So you're able to play with who you feel is the most appropriate person to make those decisions for you, even if that's not a relative or even if that's someone lower on the in their closeness of relationship with you or like as a relative to you. You're avoiding court expense and intrusiveness in that private committeeship or adult guardianship. And you're also provided the ability to give somebody authority to help make decisions with you, that supported decision making, rather than only making those decisions on your behalf. You're involved throughout the entire time. We don't just go to the best interests at the very end. So this is kind of a helpful chart that summarizes the different types of documents and then those non-document approaches. So if you don't do anything, what your temporary substitute decision maker can do and where committeeship gets you if that's the last resort. Again, you know, these 2 documents as a combination for those who have the capacity covers everything and very broadly. This document, the Section 7 representation agreement, RA7, covers everything for those who don't have the capacity to make those other documents above. But there are limitations, and I mentioned that it's a compromise for the lower capacity threshold. But advanced directives and temporary substitute decision makers, not only are they just restricted to healthcare decisions, but their abilities in those areas are even limited. So let's try and get covering all of our bases. My apologies for the baseball pun. I'm still affected by the Jays loss, but you're covering all our bases here, and by making these personal planning documents together, or this one alone, if we are not meeting capacity. Okay, that's the end of the substantive portion. I just want to say a few words briefly about the Nidus registry. So it is an online and self-managed registry where you can register the location of your original personal planning documents, and you can also store PDF copies. And but not only documents, but also information. So we have personal information summary where people can include who their professional advisors are, their bankers, their accountants, etc. Kind of the last 4 digits of some of their key accounts if they want, just to provide people with a guide to information about your life in case it's needed. People put their medication history or daily medications on there. Some amount of medical history can also be uploaded if you want. Again, so that in a case of concern, it's stored somewhere for you should anything happen in a flood, a fire, heaven forbid. But also you can permit others through the registry to have access on a document by document basis. So you can allow your representatives and monitors to have access to your representation agreement. You can allow your attorneys to have access to your enduring power of attorney if you put a copy up there, if you've registered a copy. So it really helps with communication. It can tell people where this thing is and provide a copy of it. And it's online, so it's kind of your own access point. And we operate this as a separate service. I would say that registration of a representation agreement is not required. The registration doesn't make it any more valid or legal. This is after you've already made the valid legal document, you can register it with us. And it's really just about convenience, communication, and storage in case of emergency. So I will say that it is a paid service, but our fees have not changed in over 20 years, which is wild. And we want to continue offering that. It's all one-time fee, so not by subscription, and there's no additional costs for you to access what you've uploaded. So it's a one-time fee for registration of $25, and that includes the registration of one document. And then to register additional documents, it's $10 for each document after that. You know, you are allowed to give some people permit access to others. And so we have gotten calls about people having lost their documents on like Christmas Eve, and we've been able to connect them with information that their representative needed. Or after a fire and somebody had thankfully uploaded copies of their insurance documents and their IDs so that they had something to go off of later on. So very convenient, not required, but it's out there, and we hope it has really shown benefits. And if you are wanting more help, we do have one-on-one meetings that you can book. If in person in the Lower Mainland is what we're offering only right now, unfortunately, but we're hoping to develop more of a team outside of the Lower Mainland, hopefully coming to the interior soon, like Kelowna area, but we'll see. keep informed. Right now, we're offering it in the Lower Mainland at the South Granville Senior Center, in person, with our fabulous volunteer Maureen, who's been doing this for a very long time with us. If you want to make an appointment with Maureen, you can call this number at the South Granville Senior Center. They just help us with bookings. We encourage a donation of $5 there, but that is not required. It's otherwise completely free. And you
Great.
don't have to be a senior either to get that, to make an appointment. It just happens to be at the senior center.
Great. Martina, I'm going to ask you just to leave that previous slide up.
Yes.
Just so while I maybe go through some of the questions, we have a lot of questions to
Great.
get through. So I'm going to get going because
And
our
can I
time is
say
a bit.
one more really quick thing? I'll
Oh,
leave this one up, but I do also want to say that if somebody in your life is eligible for Community Living BC services, and that's for a program that deals with people with developmental disabilities. We do have on the phone help for people who are eligible for those services. So you can email the info@nidus.ca and you will be able to, we can hook you up with one of those online or phone calls. But I'm going to leave
okay.
this one up for
We
now.
we have about 15 questions, so
Okay,
I'm
let's
going to
go.
have to get you to answer them quite quickly,
Okay,
unfortunately.
yeah.
Two quick ones that are just related to the registration.
Mhm.
Where is the information stored? And are NIDAS PDF copies legally used, or do they have to be originals to use it, like bank,
Yeah.
CRA, that kind of thing?
Yeah. So where is the information stored? It's all Canadian data centers. It's developed by Gravity, which is a Canadian software developer, and more information is on the NIDUS registry website about all of that. We have a lot of
Great.
facts and questions about that. NIDUS PDF copies are not legally used. We do have resources about how to go about using your documents, your planning documents with banks, CRA. There's a lot of resources on our website. Usually they want to see an original at first, and then they can take their own copy and then go from there. You've shown them the original. Sometimes it's convenient for you to get notarial copies. That can be, that can be costly, but you can get a notary, UPS, and then you can give them that, which is as good as the original, and you just don't have to worry about where the original is. But the NIDUS online copies, no, but they can certainly be helpful if like something's been destroyed. At least we have something to go off of. Okay.
Great. Thanks very much. And actually, there's a few things. I did want to share that Maria Lynn had shared. I really appreciate NIDA's support. In the last year, they helped us with a Rep 7 all agreement for my brother. Then recently, they helped with revocation of the agreement from February because she'd lost the original.
Oh,
We've now posted the September Rep 7 agreement to NIDUS on my brother's account.
cool. That's
Um,
awesome.
it
Thanks.
is. She goes on to say, unfortunately, the Rep 7 agreement is not widely familiar to nor accepted by financial institutions or some government
Mhm.
departments who would recognize the power of attorney.
Mhm.
And so, just further on that, I'm wondering what recourse do we have if a bank doesn't acknowledge the RA7? Or even we've had situations where people have told us the bank has not accepted an EPOA. They want their own. And lots of times, by the time it's being used, the person is no longer in a position. So
That
is
is,
there any recourse?
it's so frustrating. So the first thing I will say is exactly those rep agreements, the RA7s, it's true, less knowledge about them because less people are using them. But we are advocating that, firstly, if you want, let Nidus know about it. You can email us at info@nidus.ca, and we'll provide some guidance. But the general guidance, we like to know about it because we can also do some pushing back and doing other things in the background about working with partners, etc. But the general suggestion is escalate it to a manager or supervisor, because they usually are more inclined to or better trained and do understand the document. Uh, and it also helps because then you're telling somebody about their lack of training, and so they can address that at the organization. The other thing, and it's kind of a weird one, but just try and get somebody else on the phone. Like it with Service Canada, again, sometimes somebody on a different day just happens to have worked on a file with an RA7 on it before. So trying to like call on a different day or just hang up and get somebody else can sometimes be effective. It's even what I did sometimes in my legal practice, which sounds silly, but it can work. So you're absolutely right. And then the last thing is, again, we do have resources on the Nidus website of tips about using it with for health or for financial affairs. And a lot of these tips are in there, and they have some others as well. Thanks for bringing that up.
Right. Yeah, there was quite a few questions related to POAs and
Yeah, and I'm
RA7.
surprised. Okay. Going to the other part of the question about the enduring power of attorney when they are requiring you to make a bank version. Strongly push back against that, because an enduring power of attorney in a form that's been prepared by a legal professional is usually is your right to have, and adding further hurdles is not, it should not be required. So again, you ought to escalate those as well, if you can. I will say that Nidus does not have forms, or we don't help with the preparation of wills and enduring powers of attorney. So sometimes you'll have already a legal professional assisting with that. So sometimes getting them involved, although it can be expensive, also helps, if you want.
Great. And one thing you had said early on, and then you covered it again. Cheryl said her understanding is that the rep agreement does need to be signed in front of someone, two witnesses. Is that right?
Yeah.
And it
Mhm.
seemed to me that you said that the person creating the rep agreement needs to sign it in front of witnesses, but that other people do not.
That is exactly right.
Okay,
So representation agreement, uh, individual making it signs before two witnesses that meet the criteria in the law, in our resources, and then the representative, the alternate, and the monitor, if required, they do not need to sign before any professional. It is just a signature on the paper.
great. Um, Dave had a couple of questions. If my wife has made an RA9, do I need a POA to make financial decisions? And does a POA cover real estate?
Yes. Yes to both those questions. Great questions. If the RE9 is already in place, and your wife still has capacity to make an enduring power of attorney, that's the document, that's the companion document for financial and legal affairs. And the power of attorney will cover real estate. If she no longer has capacity to make the power of attorney, she can make an RA7 that covers just financial and legal affairs to fill the gap, but that will not cover real estate. And so you might have to look for additional advice around that if that's a problem for you.
Thank you. Yeah, I did really appreciate you pointing out that an EPOA is needed for real estate, because we certainly have heard
Always.
situations, as I'm sure you have.
If like the general advice is like, if you have real estate, just do the power of attorney. Yeah.
So, on that, then, somebody asked, if you don't have real estate, is an enduring power of attorney necessary? And as a small kind of side, what's the difference between a POA and an EPOA? The
Yeah.
enduring, yeah.
Yeah. So I'll take that question first, which is what's the difference between a POA and an EPOA? Um, POA just stands for power of attorney. A lot of people condensed condense the EPOA to just POA. But when we say EPOA, meaning enduring power of attorney, we're specifically talking about those types of powers of attorney that endure, continue after the mental capacity of the donor or of the creator of the document has gone, or they're no longer capable. So it endures and somebody else can use it after. The first part of that question was, if you don't need, remind me again, if you don't have real
It was if
estate, do
you
you need
don't
a
have,
power of attorney, right?
yeah,
I'm gonna just go back in my little, sorry about this, where are we? Oh my
okay.
gosh, it's all the way at the back. Okay, here. Sorry, the webinar, the chat is like getting in my way. Okay, the uh, so if you don't have real estate, do you need an enduring power of attorney? I think you need some sort of legal or financial decision-making document. So I would recommend the enduring power of attorney because we don't know what our future will hold. What if you inherit real estate? What if you never know? So if you can do it, why not? Some people will make an RA7 because they don't have real estate. They'll make an RA7 because they can make one with financial and legal decisions. But like I said, it's still subject to the limitations. So the no real estate rule. So we don't recommend this approach, but it is available. So we can still tell you about it. But I would say if you're able to meet this definition of capacity, still make it, because you never know what's down the road for you. Okay, so we want to cover our bases if we can.
One thing Cheryl notes in the chat, which I think is so important, she said the other thing I recently learned is that older POAs done a while ago don't necessarily include the covering of real estate. She says it was new to her elderly parents.
Mm.
So, and
Yeah,
that,
and you might just because time has gone by, the practitioners have more recommended types of powers of attorney that they find are more effective at financial institutions because they have a lot of powers in them. So I think it's also a good rule of thumb to review the documents if you can. But if you have something, it's still always better than nothing for the future. Yeah.
great. And that actually was kind of along with another question, kind of how often should they be updated? And somebody specifically asked, should an advance directive be updated regularly
Yeah.
slash annually?
If the advanced directive thing is really something that you want to have an advanced directive, I think it does behoove you to review it regularly because of just the nature of technology and medicine and things that are much smarter people are taking care of than me. But for reviewing your documents, the rule of thumb there, I think, is like at least every 5 to 10 years. Like if you haven't looked at it in 5 years, it's probably time to do that, certainly by 10 years. And then the other old thing that an old mentor of mine told me was changes in your life or the people in your life. So hatches, matches, and dispatches. So hashes when people are born, Matches, marriage can change things, and then dispatches when somebody's passed away. So just look at your documents to see if any of those people are involved or if those plans need updating because of some of that.
Okay, I think I can get time for one, maybe two more.
Yeah.
Jobst asked, is a monitor mandatory?
A monitor is not always mandatory. It is mandatory for representation agreements, sorry, RA7s that cover financial and legal affairs. And there are some exceptions to that, but most RA7s need a monitor. A monitor is optional for RA9s, but there can be circumstances where it makes sense, or you just want that extra person there on your team as a safeguard. So usually mandatory for RA7s, optional for the RA9.
I don't know if this answer is going to be short enough, but I'm going to get one more
Mm-hmm.
question in.
Mm-hmm.
Michael asks, when is a lawyer or notary signature required?
Mm-hmm. So for representation agreements, either of these two documents, it's never required. Um, there's a shortcut, like you only need one witness if it's a lawyer or notary, but if you get two witnesses, you're fine. Never needed a lawyer or notary. Sorry, I'm going to make this small again. The enduring power of attorney technically also doesn't need a lawyer or notary signature, but real estate, you're going to need the a lawyer or notary signature. So again, generally for everybody, I say representation agreements, no lawyer or notary signature needed. Enduring power of attorney, highly recommended to do it before a lawyer or notary, because that's going to be part of the real estate powers that you want in it.
Thank you so much, Martina. I feel like we made you work right to the very last moment. Thank you so much to everybody who participated today. So many questions in the
Yeah.
chat, lots of thank you. And I'm going to be so grateful to have this up on our website.
Yeah, exactly. I'm just going to fly to my very last slide and leave it at that. Again, info@nidus.ca is our website. And to learn more about and get all those resources, here are the two websites. If you go to one, you can get to the other. Okay. Thanks, everybody. This was great.
Fantastic. Thank you very much.
Bye now.
Bye.